Welcome to the War Room, a weekly roundtable discussion that takes place every Sunday at 5 p.m. Eastern Time. Tune in at 911warroom.com/Zoom.
Good afternoon, everyone. It is 5 o'clock. This is January 23rd, 2022 in the 911 War Room. Thank you all for coming. Mick Harrison will be joining us shortly. I imagine he'll be here any minute to discuss the results of the oral argument that took place on the 21st, this past Friday. Welcome back, Ernie, Sean, Tom, Ed, Al, Sandra. Looking through the, let me share my screen. Looking through the new news for 9/11, nothing up in mainstream. Corporate media pops up. I'm getting a lot of results on games and things like that, but nothing specific to 9/11. Richard Gage. Let's see. Who was his last interview? I should know this.
Yeah, it was Barbara Honegger.
Oh, yes, thank you. I didn't listen to all that either. I wanted to. The stream for YouTube was messed up. He did get it up there, but I have not listened to it yet. I caught the beginning of it. Want to listen to that yet?
Adam did a critique of it, just FYI.
I did see that pop up. I scanned the first 5 minutes. Yeah, he took 2 hours. There's Mick there. So let me do a brief introduction to Mick, and then we'll get started with that. So if anybody doesn't know, Mick is the litigation director for the Lawyers Committee for 9/11 Inquiry. He's a public interest attorney, graduate cum laude of the University District of Columbia School of Law. He's a national practice focused on causes that involve whistleblower protection, government accountability, corporate fraud, and false claims, and dangers to the public health. So this past 21st of January, Mick presented oral arguments to the Second Circuit Court of Appeals in the Southern District of New York. He gave a debriefing quickly right after the oral arguments, and he has since been on 2 programs. That was Kevin Barrett's radio show. You can catch that recording somewhere, and also The Other Side of the Radio, I believe is that radio program. They did a good interview there. Unfortunately, didn't have any questions, so if you guys do have questions for Mick at the end of what he shares with us here, save them for the end. So
And
Mick,
he had the debrief with you right after the oral arguments.
yes, thank you. But thank you, Mick, for joining us.
You want to unshare the screen so that we can all
Yeah, let me stop that, and I'll make Mick the focus.
Hello, everybody.
Hi, Mick.
So thank you for having me again, join you. So Gene and Sandra, I don't know how you would prefer I do this. I was thinking of giving a capsule summary of what brought us to the Second Circuit, and then a capsule summary of the argument, and then taking questions. Would you rather I do something different?
No, that sounds great. Thank you.
So for those who haven't followed as closely, the Lawyers Committee, architects and engineers, 3 9/11 family members, 2 Ground Zero responders, and Richard Gage together brought a lawsuit in the Southern District of New York federal court. And the goal was to compel the U.S. attorney to deliver the petition to the special grand jury that all of us had prepared. And that petition was signed by not only the plaintiffs, but about 2,000 to 3,000 other folks. And the goal of that petition was to share with the federal special grand jury the evidence of the use of explosives at the World Trade Center on 9/11, which is unfortunately quite compelling scientifically. And we did basically catalog that evidence, summarize it, present it with the law to the U.S. attorney, asked that it be submitted to the special grand jury. Many of you know by now that the U.S. attorney has a duty under federal law to give the petition to the special grand jury. It's not really within the U.S. attorney's discretion to withhold it, but the U.S. attorney did withhold it. So we did sue. The district court, to make a long story short, dismissed our case, concluding that none of the plaintiffs had standing legal eligibility to sue. And that was a mistake, as we explained to the Court of Appeals. The district court made the standing decision on 3 of the 4 of our 4 claims. For those who haven't read the complaint, there were 4 different legal claims. One was a First Amendment claim that we had the right to petition not only the U.S. attorney, but also the special grand jury, and that right was obstructed by the U.S. attorney by not delivering the petition. Fairly simple, straightforward claim under the First Amendment. I'm sure you all know that every one of us has a right to petition the government under the First Amendment for redress of grievances. So the court unfortunately the district court lumped that count in with our 2 mandamus counts. The mandamus counts, to make a long story short, are simply claims that the U.S. attorney failed to perform a mandatory duty, and the federal law allows us to compel the U.S. attorney to perform its mandatory duty. And again, for those who aren't students of the federal law, the mandamus statute is an important one to know about. Any citizen can use that statute to sue any federal official who has failed to perform a mandatory duty. Can't be a discretionary duty, but if it's mandatory, you can sue to compel the performance as long as you're impacted in some way legally recognized by the failure. So the district court mainly erred by not making a distinction between our First Amendment claim and the mandamus claims. That makes a big difference for standing analysis normally. The reason is, under the law, if the government obstructs your exercise of a First Amendment right, that is considered a legally cognizable injury that will give you standing to sue just by the mere obstruction of the right, regardless of any other consequences, if you can show, and which in this case is obvious, that the actions of the defendants caused your injury, which in this case would be obstructing delivery of the petition, and that a court order that you seek in your lawsuit would remedy the injury, which is obvious in this case because the order we want is an order to tell the U.S. attorney to deliver our petition, which would solve the problem. So we should have won on standing in the district court in our view, because it's a fairly simple analysis. We did not. We appealed, which brought us to the Second Circuit U.S. Court of Appeals, which is where the argument was a couple of days ago that we're talking about. That argument came after a series of legal briefs were filed, and it's the culmination of the appeal. It is not really the heart of the appeal. A lot of folks don't realize the purpose of an oral argument. Some folks may think logically that it's a time for an attorney to make an inspiring speech on the entire case. That unfortunately is impossible because they only give you 10 minutes per side to make your argument. But it doesn't matter because that's not the purpose of the oral argument. The purpose of the oral argument, as they teach us in law school, is to answer the remaining questions that the judges on the panel have to help them better understand your arguments, to increase your chances of winning. And it's really an important opportunity because if you didn't get that chance to be asked by the judges what they wanted to know, you would have no insight into what they're thinking and no ability to focus your arguments on what might actually make a difference in the outcome. So you may have noticed, for those who listened, I was interrupted a number of times with questions by the panel. That was a good thing, not a bad thing, because it's what you want in an oral argument. You want to know what the judges are thinking about and wondering about so you can speak to it. And that gives you a better chance of winning. So the fact I didn't get to give my prepared wonderful speech was not a bad thing. The interaction with the judges is really what you're looking for, and it gives you the best chance of changing the outcome. So we had the argument. When you're the losing party below, which we were, the appellants, you're allowed to reserve a portion of your 10 minutes for rebuttal time after the government makes its argument. We did that. It's generally wise to do that in a public interest case because you never know what the government's going to say that might leave a misimpression that you're going to have to correct. and your chance to do that is in rebuttal. So I gave an 8-minute presentation. The government then gave about a 6-minute presentation. They did not use all their time. And then I did do my rebuttal, ran out of time in the middle of a judge's question. And the judges were kind enough to not only let me answer that question, but also to answer a couple more. So I actually got a little more time than I was allotted, which was a good thing. So Gene, I think I'll stop there and see if that provokes any questions.
Actually, I have a couple there actually. And I know that from your interview that you did with Daniel Sheehan and Barb Honiger, they touched on this a couple times. The one judge, I think it was Judge Walker, he asked why you petitioned the government for a grand jury instead of petitioning the court. Now, after listening to Daniel Sheehan and Barbara Honiger ask their questions, I think I got this down, if you could help me. When you petition the government, that's the Attorney General by statute, that's the 18 USC 3332. They're required to present that information to a grand jury as opposed to petitioning the court, and you'll have to help me out what that means.
Okay, so it's a good question, Gene. It was a good question from Judge Walker. We actually had contemplated that option before we sued. And the reason it's an option, and to tell you what the option is, you can either essentially demand, you don't call it a demand, but it really is a demand, that the U.S. Attorney give your petition to the grand jury, because the U.S. Attorney has a mandatory duty to do that under the explicit language of the statute. So because the statute gave us not only a right to ask, but essentially to demand, because it was a mandatory duty for the U.S. Attorney, we used that option. There is another option in that very same statute, Gene. It's still 18 USC 3332A, which also says that the other way evidence can be presented to a grand jury is through the court, which means we could have asked the court itself, the judge, to give our petition to the grand jury. Now, technically, we did that. We mentioned it in our complaint, but the court didn't pick up on it and didn't decide that question in the district court, so it didn't become an issue on appeal. It was a backup, only to be reached if the U.S. Attorney didn't honor its duty and if the court didn't enforce the duty. But because the district court didn't speak to it, and because the language for the court is not mandatory, and that's the key here, the statute does say the court can do it. It doesn't say the court must do it or shall do it, which means it's within the court's discretion to do it or not. So we could have tried it. We could not have enforced it. And we could try it again later if we want.
So the statute 18 USC 3332A compels them to present it, but doesn't the First Amendment trump them to do it, if you will?
I would probably agree with that, Gene. The First Amendment, well, okay, this is a little bit of a long legal story, more than it should be, but let me give you my answer and also what the law says at the moment, which isn't exactly my answer. My answer is more your answer. So under the First Amendment, every citizen has a right, and the court acknowledges this, so did the district court below, to petition the government for a redress of grievances. However, the U.S. Attorney and the Attorney General now are arguing that, yes, but there is a carve out, even though no court has ever created the carve out that the government wants. There's a carve out for grand juries because in the government's view, the First Amendment doesn't give you a right to petition grand juries. Now, there is no carve out. The Supreme Court and the circuit courts have always said when they talk about the right to petition, they talk globally, the right to petition every branch of government and all components of the government. There's never been a carve out for the grand jury. So I would adopt what you said for two reasons. One is we have a right to petition the grand jury, and there is no carve out that exists in law yet, unless the Second Circuit tries to create one in this case. And I hope they don't. And I don't think they have the power to, because it would be contrary to the Constitution. So we have the right to petition. The next question, Gene, is under the law, just how far does that right to petition go? Judge Walker actually asked this question also. He said, isn't the law clear that even though you have a right to petition, you don't have a right to be heard, and you don't have a right for the government to respond to your petition? And my answer to him was, and you probably won't like it any more than I like it, but it is the law at the moment. The law does say, meaning the law created by judges, that even though you have a right to petition, it's the government's discretion whether they respond or not. So a right to be heard, in my view, means a right to get a response, or at least have the agency read what you submitted. The law in the courts at the moment is that you have the right to petition, but you don't have a right to a response or to be literally heard, meaning that the agency must read what you filed. They can ignore it if they choose under the court-created law at the moment. Now, is that consistent with the Constitution? There's a body of academics, legal academics, who have written a number of law review articles saying the right to petition includes the right to a response, the right to be heard. And there is a dissent in a case, I believe it was the DC Circuit, where one of the judges said, you know, this is an evolving issue. The academic community is probably correct that there is a right to be heard under the First Amendment, not just a right to petition and have something delivered, but a right to be heard. This was a circuit judge in the DC Circuit saying this, but he was saying our hands are tied as a court of appeals by the US Supreme Court, which the last decision from the US Supreme Court was there's a right to petition, but not a right for a response or to be heard. So that is the ins and outs of that question, and why Judge Walker asked that question. It does not control our case in the moment, though we should still win, notwithstanding that unfortunate status of the law, because we aren't demanding a response from the grand jury. We actually have confidence in the grand jury that once it sees our petition, once it gets handed to the grand jury, that they'll read it, because it's a compelling petition. It's a issue of great public importance. If you were on a grand jury, one of the 18 to 23 citizens, and you got a petition saying thousands of people were killed at the Trade Center by the use of explosives that's never been investigated, would you read it? You know, I think citizens would read it. The DOJ might want to ignore it, but I think citizens would read it. So we haven't demanded a response. We have just demanded delivery, and we can win that case with the current state of the law.
Thank you for that. I'm going to try. No, Sandra, tell me if you hear this or not. I'm going to try to play this clip of Judge Walker asking this question here.
Yeah, no, I can't hear it. It's the same as before.
Volume is low.
Nah, it's not going to work. Okay.
Yeah. Can I ask Mick the example that I gave you when we spoke earlier?
Yeah, we're going to be
Like
taking
what
a
I
break here
compared-
at 5:20 for a quick prayer, but go right ahead, Sandra, and then Ed, you'll be next.
Right, because when Gina and I were discussing this, trying to understand all the ins and outs of it, I said, basically what it comes down to, it's if you use the example of sending a letter through the US Postal Service, what it comes down to is like, I'm allowed to send a letter, but the US Postal Service is not obligated to deliver it to the recipient. I mean, that, you know, if I send a letter, it's with the expectation that the letter will arrive at the address that says on the envelope, right?
Yes.
So wouldn't that go hand in hand? And that's what I don't understand. Like the right, yeah, of course we have the right to petition, but isn't it implicit that it needs to be delivered? I mean,
Thank you very much. I totally agree. Gene, do you want me to respond now or wait till after your break?
Yeah, if you don't mind, we'll just take that break right now. And
Sure.
just everyone, every day at 5:20, I take a brief moment of silence. Actually, I pray. So if you're not religious, just hang with me for a second here. Lord, we just lift everyone here up to you. We just thank you for all these advocates as they continue to press forward. We just ask for continued protection and encouragement. We ask for a hedge of protection around the Lawyers Committee and Richard Gage and all of those that are fighting this fight in the front lines. Just continue to ask you would open up hearts and minds and let these truths be heard. We ask these things in your name. Amen. Thank you.
Amen.
Thank you, Gene. So, Sandra, I almost got to the point of making an argument to the court, like you just stated, and I didn't have time to do it. But I had developed an analogy similar to yours, except mine was, it was about the post office, but it was a hypothetical. Let's say we wrote a letter to the president through the mail, and the FBI was screening the president's mail, ostensibly to make sure no explosives or anything dangerous, anthrax or something was in the letters. And so they opened all the mail. And an FBI agent opened this letter, which was critical of the government on some issue. Could have been 9/11, could have been the pandemic, could have been the economy, could have been any number of things. But the FBI person reading it thought, oh, this is going to be embarrassing to the government. I'm going to send this up my chain to the head of the FBI. And the FBI director says, oh, we don't want the president to see that. We're going to trash that letter, and it gets destroyed or it gets concealed. And the president never receives it, never got delivered. So would the courts have a problem saying that that was a First Amendment violation? And I'm pretty sure they would not have a problem saying it was a First Amendment violation.
Right.
And there's some case law pretty close to that, actually. So, and that's what we're talking about here, is delivery. What happens after that is up to the recipient. And we have confidence in that recipient, the grand jury. And that's why I think the U.S. attorney doesn't want to deliver it. They're afraid of what the grand jury is going to do if they read it.
Right.
It's just, I'll go to you in a second. Ed, what I wrote was Judge Walker said at 5:33 in the oral arguments, no question, you have a right to petition the government or to submit it. But at 5:50, he says, but there's no First Amendment right for the government to act on the basis of that petition, meaning to be able for it to actually literally be heard or for them to respond to it, which is just kind of boggles my mind. Like it basically castrates the First Amendment.
Well, I think you're right. But even so, we would still win our case.
Okay.
Because our case is about delivery, not about response.
Yes.
And the court may not have realized yet, or some judges on the court may not have realized yet, that we petitioned to the U.S. attorney, not just to ask the U.S. attorney to do something, but to ask the special grand jury to do something. And the reason we did that is, sorry to report this, we don't know it yet, there's a federal statute that makes it a crime for any citizen to communicate in writing with a grand jury. Didn't used to be that way. Before there was a constitution, citizens communicated with grand juries. And even after there was a constitution, citizens communicated with grand juries. But Congress passed this statute in fairly modern times, which makes it a crime to send something to the grand jury, like I want you to investigate crime X. That's actually a crime to do now.
Wow.
But in order to prevent that statute from creating a constitutional problem, which would be intruding on the First Amendment right, and another problem, which we haven't talked about, which is making the grand jury essentially a nullity, unable to perform its constitutional duty, because the grand jury is created by the Constitution. And it has independence of the other branches, and it has a task imposed on it by the Constitution that the executive branch and the judicial branch cannot take away. And those tasks are to determine if there's probable cause to believe a crime was committed. That's one major job. That's called the sword function, to initiate a prosecution when it's warranted. The other is to determine whether something the government is trying to do would be an unjust or politically or corruptly motivated prosecution, and to prevent that by not proposing an indictment. That's called the shield function, to protect from political prosecutions. Those are jobs imposed on the grand jury only by the Constitution. And so this federal statute that makes it a crime for citizens to send something in writing to the grand jury is essentially handicaps the grand jury in doing its job. It doesn't receive evidence of crimes that it needs to see to do its job. So the way I believe Congress tried to avoid that statute being stricken down, which I think it would have been as unconstitutional, they created this statute we've been talking about, 18 U.S.C. 3332, with the subsection A, which requires the U.S. attorney to receive citizen reports of crimes that in the past would have gone directly to the grand jury, and requires the U.S. attorney to relay them to the grand jury. So there's no obstruction of delivery. And that probably saves the constitutionality of the other statute, which makes it a crime to communicate with the grand jury if it is enforceable, if it is followed. In our case, the U.S. Attorney says, no, we don't have to do that, and citizens can't force us to do it. And that creates this other problem of essentially interfering with the constitutional duties of the grand jury. You know, if they can't see the evidence, how can they determine if there's probable cause? And if they can't see all the evidence, how can they determine if a prosecution is politically motivated? If the U.S. Attorney controls which side of the evidence they see case by case, the grand jury is not independent.
Thank you. Ed, do you have a question?
Yeah, just this is really interesting stuff.
Yes,
Mainly
it
because
is.
I have a very dear, a very personal stake in this issue because I was part of the lawsuit back many years ago that went to the Supreme Court, but it didn't get heard by the Supreme Court. Kavanaugh actually was the district court justice in the case that, and they heard this We the People Foundation decision regarding the right to petition issue. I was one of 1,000 named plaintiffs on that suit, and one of the things that was interesting about it was that the right to petition issue was brought up in our Declaration of Independence, even because that was one of the grievances that the founders had. He says our petitions have gone unanswered. That was literally a grievance. And that is a legal document, whether people believe it or not. I do believe that the Declaration is as much of a legal document as anything else because it laid the foundation for everything else that followed as far as its legitimacy. So it's interesting to see how the fact that you have a grievance that the founders laid out in the Declaration of our petitions being unanswered, and when they wrote that First Amendment, you can clearly make the claim that, hey, I think the founders intended for the petitions to be answered. Otherwise, they wouldn't have put it in the First Amendment, you know. So answering the petition would be a very, very valid claim. Now, the argument we were bringing up in that suit was the fact that even the court was saying, of course, that yes, you have a right to petition, but the government doesn't have to answer you. And it goes, of course, you're dealing with the issue of delivery, which is great. And one of the things that we were bringing up was the fact that if the government, there were three questions. Do we have the right to petition? Does the government have to answer? And if they don't answer, do we get the redress we're seeking? Because that would be another check on the fact that they didn't answer. And they never addressed the third question. The court never looked at it, never addressed it.
I think what you're talking about, sorry, Ed, I think what you're talking about is what the academic community is evolving towards agreeing with you on, and I think they may already have agreed with you on that there is a right to get an answer.
Mm-hmm. And if they don't answer, then do we get the grievance that we're seeking, or do we get the remedy that we're seeking in the grievance?
Well, it'd be sort of like a default judgment if you analogize it to civil procedure.
Sure.
But I think to get there, you first need to get to the courts recognizing the right to a response, and then you have to look at the implications of not getting a response. The courts haven't got yet to the point of saying, yes, there's a right to get a response. They may be on the verge of getting there.
In our case, they said we don't. They're
still saying that.
Yeah.
It's not just your case. They're still saying it. The DC Circuit dissenting opinion I mentioned was a very strong suggestion that if there wasn't a Supreme Court decision in place that tied the DC Circuit's hands, the DC Circuit would have taken your position in that case, that there was a right to get a response on a petition. And the DC Circuit dissent was predicting that the Supreme Court, next time it visits this, may have to come to grips with this evolving academic consensus.
Mm-hmm. Interesting. Okay. Yeah, it's a fascinating, evolving issue, that's for sure.
Thank you. We go to Alfred.
Yeah, Mick, I was surprised at how short the presentation was, and that there was no real Q&A afterwards. How much do the judges review the case prior to? I mean, I'm assuming that they hear more than what was presented. I don't know that.
They do.
They do.
Yeah, that's the requirement. Now, if a judge gets busy, do they put it off on a clerk to read the briefs and fill them in a 10-minute briefing before oral argument? I don't know. They're supposed to read all the briefs. There were 3 briefs filed, 2 by us, one by the government. They were detailed, extensive. All the proceedings below were in an appendix for them to read. They had the complete case before them in writing before the oral argument. Now, can I reassure you each judge read everything? No, but they're supposed to.
The second question I had is, this may sound naive, but how much of the political considerations of the actual judges come into play? I'm assuming they're supposed to be, there would be no personal opinions on their part that were motivated by politics, but maybe I'm being completely naive.
Well, judges are human beings, and they have their own histories and their own connections. And before they became judges, their own politics. I don't think that disappears when they're appointed to the bench. Sometimes it comes out in a trial or an argument where a bias is apparent, and there are statutes that let you ask to recuse a judge to force them to step down when that happens. If they have a conflict of interest or even the appearance of a conflict of interest, and you find it out beforehand, you can ask them to step down before the decision is made. You may remember, I think we talked a little bit about that. Gene or Sandra can remind me about our DC Circuit case where Merrick Garland was on our panel of 3 judges before he became Attorney General while we were suing the DOJ in our DC Circuit case against the FBI. And we asked for a disclosure from the court to see whether there might have been a bias or a conflict of interest or the appearance of a conflict, because he was on our panel when the panel decided to take away our oral argument that had already been scheduled. And at that time, it was publicly known he was a candidate to become Attorney General. So we asked for a disclosure. The court did not give us one. We petitioned the U.S. Supreme Court and included that issue, and the Supreme Court decided not to hear the case at all. So it never got decided, but that's an example where it actually becomes an issue.
Did you have any sense from the judges which way they might be leaning, or you couldn't tell anything?
I've given up trying to do that. I used to try to predict the outcome based on how the argument went. And unless a judge actually says, I think you're right on this, and we're going to rule this way, you can't tell, because sometimes they play devil's advocate. Sometimes they give the hardest time to the party they're about to rule for, sometimes because they want to make sure there's no appearance of favoritism, and they want to make sure there's due process, and they want to maintain public confidence in the court process. So I got more questions than the government did, but they were courteous. They were intelligent questions. I felt the judges were listening to the answers based on the responses. On that one from Judge Walker that Gene mentioned about why didn't you petition the judge instead of just the U.S. attorney, when I explained to him that the statute puts the duty on the U.S. attorney but not on the court, he basically said, I don't know if he meant it to be picked up on the microphone, but it was. He said, I see. And so, yeah.
If I could say, you came off very well spoken when they asked you questions. You didn't hem and haw. You gave an answer. You gave the answer clearly. There were a couple times when they said, "Well, doesn't Judge Lee, doesn't this pose a problem for you?" And you were like, "No." Just came right back. You had an answer right there every time, and I loved it. She said, she asked at 3:45, "Is there a case that identifies a First Amendment right to present evidence to a grand jury? Do you find this as a problem?" And Mick shot right back, "No, I don't have a problem at all." I kind of like your snarky answer at the end. You guys certainly have your work cut out for you. Something along those lines.
That wasn't meant to be. That wasn't meant to be snarky, by the way.
It wasn't, but I appreciated it.
I understand. No, I was actually saying you've got an important decision to decide, and I was sort of saying I'm glad I'm not the one that has to make it. But they do. But the judges. You're right, Gene. They asked me a couple times what would be in a courtroom in a trial. A leading question: isn't it true that such and such? In other words, isn't it true you should lose because of X? And the one you mentioned, because there's no case that says there's a right to petition a grand jury. And my response was, no, that's not a problem, because there's no case saying the opposite. And also there are cases saying the right to petition is global. You can petition all branches of government, and there's never been a carve out. to that global protection. And then the other judge in the middle, someone remind me, it wasn't Walker and it wasn't Lee, it was the other judge. And he said, isn't it true that this circuit in, what the heck was the name of that case? You probably don't care what the name of the case was, but it was a Second Circuit case. It'll come to me.
Salle?
Is that Zellick?
Was that the one that 1985 he kept coming back to?
No, that 1985 case was in our favor from the Southern District of New York. He's talking about a case in the Second Circuit itself, Court of Appeals, which the government argued overruled the 1985 case in the district court we relied on, and said there was no citizen ability to enforce the mandamus, the mandatory duty. And my Zellick, I've forgotten the spelling of it, something like that. And my explanation to the court was, no, that case didn't decide this issue, Judge. That case decided the question because the petitioner there, who did not have a lawyer, in many of these cases, the government sites are pro se, where the plaintiff didn't even have the benefit of an attorney, and they're holding him to explain this constitutional law like they were lawyers, which is difficult to do. And so the Zellick case basically got decided because the plaintiff there, who was not a lawyer, didn't ask the U.S. attorney to deliver his information to the grand jury. And why does that matter? Well, the wording of the statute, 18 U.S.C. 3332A, says if a citizen asks the U.S. attorney must deliver it. Asking is a prerequisite to invoking the duty. And the citizen didn't ask in the Zellick case. So that duty never got invoked. So the case wasn't decided on whether that duty was enforceable. And I explained that to the judge. He did not attempt to disagree with me after that.
They were receptive. They didn't seem to be caught off guard or negative about that response at all. It seems like they took it at face value and appreciated that, I think.
Well, they listened. It's a well-recognized comeback on the case to say it's distinguishable because it was decided on other grounds. The court went on to say something in that same case, which was what we call dicta, and it was sort of qualified. It wasn't a firm conclusion even then about, well, if he had have asked, the facts appear to be blah, 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 which is not a decision for two reasons. The concept of dicta is if a court talks about an issue it does not have to decide in a case because the case is decided on other grounds, it has no legal import. It doesn't have the force of a decision. And that's how you tell a court that they can ignore a decision because it was just dicta, meaning it wasn't part of the actual decision. It was sort of, what would you call it? A side comment that doesn't have the force.
Matter of fact statements made and, just like in the
Offhand.
pursuance. Yeah.
Yeah. So the court was pretty receptive to my explanations. I can't fault the process we received. We'll have to wait and see if we can fault the decision we receive.
What did you make of the government's case when, I've forgotten the guy's name that presented it, but did you see any thing that you were surprised by or?
Not in the oral argument. It didn't go beyond their briefs. There wasn't any real surprise there. They did say something that I found offensive, but it wasn't a surprise. It was in their brief, and that's where they said that the court should be concerned with opening what I called the floodgates. That's what they mean.
Yeah.
The citizen reports to grand juries, because it'll allow citizens to improperly influence grand juries by hook or crook to get politically or corrupt motivated decisions, which logically doesn't make a whole lot of sense. What power does a citizen have by writing a letter to a grand jury to, twist their arm into doing a corrupt decision? If they did a bribe, that would be different. But if you're going to do a bribe, citizens are going to try that anyway. And so will politicians. The law isn't going to stop them because it's illegal anyway. But the point I made and come back to that was that the Constitution created the grand jury not to protect against improper influence by citizens, but to protect against improper influence by prosecutors. And the whole purpose of the grand jury is to avoid political prosecutions and unjust prosecutions, which were being experienced before that constitutional grand jury body was created. You know, the king would prosecute the king's enemies and prevent prosecution of the king's friends. And so the grand jury process is intended to prevent both of those corrupt practices. So the government had it backwards in that response, but there was nothing really surprising in what they said.
Ed, question? You're muted, Ed.
Oh, sorry. Yeah, I posted in the chat a reference to a from 1774. Let me see here. Let me try to pull it up again. Sorry. It's there's a part there that says let's see here. It's referring to the Continental Congress of the Inhabitants of the Province of Quebec, October 26, for the Journals of Congress, 1:105-13, and chapter 14, reports number 12. And it says here, if there's on the second, third, fourth, fifth paragraph in the second page, and I made I sent it to the chat. If money is wanted by rulers who have in any manner oppressed the people, they may retain it until their grievances are redressed, and thus peaceably procure the relief without trusting to despise petitions or disturbing the public tranquility. Anyway, just what I thought it's an interesting piece of data there. Kind of goes to the heart of what I was talking about earlier.
Well, there's a pretty good history, and I think the courts recognized it. I made some references to the history of the grand jury in the briefs and a little bit in the argument, and I've never been questioned by that by the court or the government even. They don't want to try to dispute how the grand jury came about and its constitutional nature. You know, the government has tiptoed around the fact that if it gets its way in this case, the grand jury will no longer be independent, because the executive branch, the U.S. attorney, will control what the grand jury sees and what it doesn't see. And that completely determines what the grand jury will decide. You can't indict someone as the grand jury based on evidence you're never allowed to see. And if you see evidence, that's only what you might call the clean evidence about prosecuting someone. Let's say the government wants to prosecute a political adversary and it's really a political prosecution. If the U.S. attorney is still controlling what the grand jury sees, the grand jury doesn't see the incriminating part that shows the political motive or the retaliation. They just see what looks like maybe a real commission of a crime. It might even be fabricated evidence. So, I mean, there's a lot at stake here in terms of the constitutional role of the grand jury.
I have two more quick questions, if you don't mind.
Yeah.
One, this is really simple. The grand jury, they would have subpoena power, and they would also have, I'm asking, and discovery of all relevant evidence.
Yes, and yes.
So
let me tell you something, Gene, to put punctuation on that and then finish your thought. The Supreme Court has said, I forget the name of the case, it might have been Brandsburg, that the grand jury has an obligation to do what I call turning over every stone to investigate a case. The grand jury said to explore every clue and examine every witness to get to the bottom of whether a crime was committed. But go ahead.
Sandra and I were talking. Basically, this isn't a trial like somebody's on the stand and being grilled by the grand jury. This would be more like a presentation of evidence. Is a subpoena the same thing as an indictment?
No.
Or at what point does
I can help you with that.
Thank you.
So the process with the grand jury is different, as you say, than a trial. It's very one-sided. And if it actually led to a conviction or a punishment, it would be unconstitutional itself. But because it only leads to a proposed indictment that then leads to the trial process, where the defendant gets put on notice, can, you know, put evidence on their own behalf and get through process, it's not considered to be so one-sided to be unconstitutional. It is a little unsided. What happens is The grand jury calls in the witnesses they wish to see. That's what should happen by the Constitution. They subpoena what records they want to see, and they get them. They get the records and the witnesses, whether the party who holds the documents wants to give them up or not. The subpoena has the power of law to compel the production, and the subpoena has the power of law to compel the witnesses to show up. And even when they get there, and if they want to say, well, I'd rather not testify, I'd like to invoke my First Amendment right against self-incrimination, that would work for them in a criminal trial, and they wouldn't have to testify. For the grand jury, if the grand jury says, well, we're going to give you immunity, so go ahead and answer our questions, they have to answer the questions, but they do get immunity, which means they won't be prosecuted on what they disclose. Ostensibly, now there are ins and outs in that, which defense attorneys will tell you there are some problems. If the government ends up finding evidence independent of the testimony, they might still get prosecuted on the same crime. And the prosecutors might not know where to look, except for hearing that evidence that was given immunity. So it's not a perfect system. But all the more reason the prosecutors shouldn't be allowed to control it, because it's prosecutors who are prone to do those sorts of tricks. It's not regular citizens.
Thank you.
And the duty of the prosecutor is to seek the truth too. So they have an obligation on their part.
They have a statutory obligation to do that. They tend to forget that. Government attorneys tend to treat cases like they're corporate lawyers just trying to win the case any way they can. And they feel like that's their ethical duty. Their ethical duty is under a statute to make sure that justice is done and the law is followed, whether or not it benefits their client, the government agency. And, they need to be reminded of that now and again.
Last question I have is something that Ed did several years ago, and it kind of hints onto what Judge Lee had asked, I believe. Can we be petitioning each of our state's attorney generals, or courts for a criminal complaint to a grand jury, if I'm even phrasing that right?
Close. But the answer is state specific. And I could only probably give you an answer for Pennsylvania, since I'm a member of the Pennsylvania Bar.
Sounds good to me.
However, I haven't researched the Pennsylvania law on that recently. So even that, you're going to be handicapped from getting an answer from me. But the short version is subject to research in each particular state. Most states are similar, but some are not, to the federal law. And generally speaking, there would be some mechanism in each state, either through a petition like we did, or through a petition to a judge, like Judge Walker was asking about in our argument, to get evidence in front of either the state attorney general or the state district attorney, the county district attorney, or the court, to be passed on to the grand jury in the state. There is almost certainly some mechanism to do that in each state. What exactly it is, we'd have to research for the given state. And what the state of the law is in that state on the questions we're now arguing on the federal level would also have to be researched state by state.
So, but no crime has been committed in my state of Pennsylvania, though. So how would
I wouldn't say that.
Yeah, Shanksville, my friend.
Well, not Shanksville, but specific to the controlled demolition of 1, 2, and 7.
Well, that's true and not. If the crimes are all one conspiracy by the same conspirators, then you got one multi-component crime.
Okay.
And you may, this hasn't been decided anywhere, but it's an interesting question. Any part of the 9/11 crimes that happen in any state, that state might have jurisdiction to look at the whole ball of wax.
Also, remember, Gene, some of the suspects that we're looking at, like those Israelis who went back and who were arrested, actually held by the FBI.
The high fivers.
Yeah, they were actually caught. There was an urban movie system van caught in Pennsylvania. They were pulled over by the police.
I think that's right.
Yeah.
Point H in the material witnesses of the lawyers committee. Yeah, lawsuit.
Well, I have a question basically on what can we expect, like what would the outcome look like now? Would you, I know you said it could take a few days, it could take a few months, but
Right.
when the decision does come, what will you be informed of? Will they tell you, yes, will they confirm, yes, we will deliver it to the grand jury, or will they just say that, yes, we've made a decision and you're not finding out what it is?
I don't think they're going to do that. I don't think the Court of Appeals will do that, the latter. I think they're going to be making an explicit decision that will say one of several possible things. One of the possibilities is the Second Circuit could do what we've asked, which is reverse the district court dismissal of our case, find that we have standing, either on the First Amendment claim or the mandamus claims, or both, and I think it should be both. And if that is done, then the Second Circuit can either remand and send the case back to the district court to decide the merits of those claims, and the merits are fairly simple. You know, did the U.S. Attorney have an obligation to give our petition to the grand jury? That's the merits of the mandamus claims under the statute. The statute is clear. Well, the government has tried to weasel around that duty. I don't think any court has ever really said the duty doesn't exist. The dispute has been whether citizens have standing to enforce it. If we get a decision on standing in our favor from the Second Circuit, and we get a remand, I think the district court is going to have a hard time not ruling for us on the merits and upholding that mandatory duty. Now, the Second Circuit could decide beyond standing whether that duty in the statute exists, which it pretty clearly does. I don't know the government's really put that in issue, but if they did, the court at the appellate level could even decide that as a question of law. The court could also decide whether we win or lose on our First Amendment claim after finding we have standing. In other words, decide it on its merits before even sending it back to the district court to do that. It has that option. The government actually asked, people may not have picked up, the government actually asked in their brief, perhaps recognizing they had a weakness on the standing issue on the First Amendment claim, that the court should go ahead and, if it found standing for us, go ahead and decide against us on the merits of the First Amendment claim, making the argument that you all have raised in this discussion about whether there's any obligation on the government to respond. And that's a confusing and misleading argument, because as I think I've made clear, our case is only about delivery of the petition, not about getting a response to it. And I would be surprised. I mean, it's possible. The only way that Second Circuit could rule against us, Second Circuit, on the merits of the First Amendment claim is to carve out, for the first time in history, a part of the federal government not subject to the First Amendment right to petition. And because the Supreme Court has already said that right applies to all the government, I don't think the Second Circuit has the power to do that. So we could well get a decision in our favor, not only on standing, but on the merits, which basically means we could win, and the U.S. Attorney would have an obligation in response to the Court of Appeals decision to hand our petition to the grand jury.
Thank you. Anyone else? Questions for Mick? Just want to share one thing that Barbara had touched on. This was Anton Scalia making a statement about the grand jury. The boldest quote there is, "The Constitution of the United States, as interpreted by the Supreme Court, gives rise to a fourth branch of government, the grand jury." I'm not going to read all of this, but the main quote there: "In fact, the whole theory of its function is that it belongs to no branch of the institutional government, serving as a kind of buffer or referee between the government and the people." I give some case history there. Although the grand jury normally operates, of course, in the courthouse and under the judicial auspices, its institutional relationship with the judicial branch has traditionally been, so to speak, at arm's length. Judges' direct involvement in the functioning of the grand jury has generally been confined to the constitutive, one of calling the grand jurors together and administering the oaths of office. So,
yeah, that decision is consistent with our position, and pretty much with every decision I've ever read about the grand jury anywhere, which is it's a constitutional fixture of the federal government created independent of the other three branches. It works with the executive branch, it works with the judicial branch, but it is neither, and it is controlled by neither. And that's, that's an important concept here. And one of our arguments to the court in the briefs was the government is asking the Second Circuit, by refusing to let us enforce this duty or to exercise their First Amendment rights, it's going to basically insulate the grand jury from citizens, have it controlled in terms of information flow by the U.S. Attorney. And so it will no longer be what the Constitution created it to be, which is an independent entity. And the U.S. Attorney will have usurped the power of the grand jury. And no court has the power to do that.
Excellent. Anyone else? Mick,
Yeah,
thank you so much for making yourself available. I appreciate it so much. I think everybody here does.
You did.
Yeah,
Ed
thank
have,
you, man. Appreciate it.
hang on. Did Ed have something before I go?
No, you were great.
Okay.
I had a
Oh, sorry.
question.
Yeah, Alfred?
I had a question. Under what circumstances can you imagine this ending up in the Supreme Court based on the appeals court sort of punting on the whole thing?
Well, it actually could end up in the U.S. Supreme Court, even if the Second Circuit doesn't punt, because this is an important issue of law on an important issue of fact, the 9/11 crimes. Whichever side loses at the Second Circuit is probably going to petition the U.S. Supreme Court. So if we win, the government may petition. And I can pretty much assure you that if we lose, we will petition. So I think, the Supreme Court may be asked to look at it. Now, we might end up making some deal if we win. The government, I don't know if the government wants the Supreme Court to decide this, because even if they lose in the Second Circuit, they may be happier living with this rule in one circuit rather than having the U.S. Supreme Court impose it on them nationwide. So I wouldn't care to predict what the government would do in its wisdom if we win. I'm not even sure, to be honest, whether the new administration, the Biden administration, has come to grips with what this case means. And it started in the prior administration. I believe I put an inquiry into the U.S. Attorney after the election saying, would you mind asking your client, the new administration, whether they still agree with the position taken by the prior administration in this case? I don't think I ever got an answer back. So I don't know. There's a question in my mind whether Merrick Garland and President Biden actually know about this case and approve the posture, which is a very important one in terms of constitutional rights. We may have to press that a little bit as we go forward.
If this does go to the Supreme Court, I know several who would be more than happy to write up amicus briefs on our behalf.
Well, we may put out a call. We may put out a call for a friend of the court briefs even before the Supreme Court petition. There is one other step. Whichever side loses with this panel is 3 judges only from the Second Circuit. There are many more judges in the Second Circuit. I haven't counted recently, but 15, 20, 25, something like that. There is an option to petition the entire court en banc to hear an appeal after a panel decides it. So either side in our case could ask the entire set of all judges in the Second Circuit to revisit the panel decision and make a new one before it goes to the
That's
Supreme
very
Court. Yeah,
That's very interesting. I never heard of that option before.
it's called en banc, a petition for rehearing en banc.
Okay, interesting. Learn something
Okay.
new every day.
A little off topic, but real quick, if you wanted to touch on it, I remember you were working with Dave Cole, and then 4 days you had to respond to something. I'm just wondering if you could give us an update on that real quick.
Yes, and that's another federal litigation that's moving in the right direction. And so, people sometimes get pessimistic about the ability to make progress on 9/11, particularly through legal avenues. Not that we've made major progress through political avenues or the press for that matter. But apart from getting a hearing in person with the judges in the Second Circuit, which doesn't guarantee us a win, but actually is a bit of an accomplishment per se. We did a Freedom of Information case. Dave Cole, who some of you may know of, is the plaintiff. I'm representing Dave. It's against two federal agencies with which you will be familiar, FEMA and NIST, Federal Emergency Management Agency and National Institute of Standards and Technology. These are the agencies that did the studies on the building collapses at the Trade Center on 9/11 and have put the sort of official story out there for the government that the collapses were due to fire and airplanes and not to explosives. So Dave, who most of you know is a longtime researcher on 9/11 issues, he asked a pretty straightforward question in his FOIA request. He asked for all the records of all the data used by FEMA for its building performance study of how the Trade Center, Building 7, and other buildings performed on 9/11 under the stress of the attacks. And so he asked for photographs, videos, lab results, interviews, anything that would have gone into the study, which we shorthanded as data or raw data. And the immediate response he got back, as some of you may remember, was from FEMA, "We have no records responsive to your request." So yeah, if you haven't heard that before, you're gonna have to let that sink in. So you know, you got an agency that did a published report on a matter of great public importance, very technical, very long, a lot of scientists and others involved, and yet it didn't use a single piece of data for it. That's, you know, pretty amazing. So that's actually not, go ahead.
The question I would have there is, I mean, the agencies are very, very clever when it comes to answering questions like that, because they could have like transmitted that data to the National Archives.
Well, you're getting
then
close there, Gene.
And then the archives would then be holding it, so they would be truthful in what they say. Oh, we don't have that. We don't have anything responsive.
Well,
but they won't tell you
you're
what
giving
it
them
is.
too much. You're giving them too much of a benefit, but you're also right about how sneaky they are. So in this case, they did some of that actually. So they pressed them. I helped him press them as his lawyer. And basically what they ended up saying, and we respond to showing this now, is that FEMA ultimately said, well, the reason we can't give you any records isn't because we didn't have some, but we don't have them now because we gave all of our records to NIST so NIST could do its study. And then so we said, well, do you really mean that you gave them your hard drives and your emails and your backup emails and
all hard copies,
your backup storage and
originals,
all your hard, thank you very much. And they talked around it, but they basically told the court they didn't have anything left. And that's impossible really in the modern day and age. And it's particularly impossible for a federal agency because by statute, it's required
to hold records.
Yeah. So that was their answer. And so we sued them. And 3 or 4 months after we sued them, they gave Dave, through the lawsuit, 3,900 pages of records that they had been withholding. And we have those. And I don't know if they're up on our website yet, but they will be. But they still withheld some very key documents. So we ended up getting correspondence where they had told each other, FEMA and NIST, that these 3,900 approximate pages of records were releasable under FOIA. They were not exempt. And even after determining that they were releasable, they held them for like 3 years. And then they gave them to us after we sued, which means we're going to eventually win this lawsuit. It's not over, but we've already basically won it for that part alone. But on the other part, they didn't give us key video, key photographs, a couple key CDs, some key drawings, a few other things that Dave recognized as existing because he had found, and I confirmed, that these were referenced in FEMA and NIST public documents as existing, but they weren't given to us. So they were still withholding key stuff. So we ended up doing dueling summary judgment motions in that case before the federal court in DC. And the judge, a senior judge, referred the matter to a magistrate judge. About a year ago, the magistrate judge recommended in our favor that the government's motion be denied and that we be granted discovery to find out what, basically what kind of surge did the government do that didn't allow them to find these missing records? What was
Especially
the, ahead.
especially since they've already said, oh, we don't have anything, and then they popped up with 3,000 records. It's like, well, your credibility's shot now. It's
Well,
like,
yes and
what-
no. I mean, they did what you said, Gene. They tried to play a game with it, saying they gave it to NIST. NIST then gave it back to them. Now they can give it to us, but that didn't account for the missing records.
Mhm.
And so we're going to get discovery where we can subpoena records regarding their search for the missing records. We can interview witnesses from the agency under oath in a deposition, real time, to find out what did they do to search, why didn't they find it, how did they handle these records, and we can ask them to respond to interrogatories under oath about how they did their search. So the discovery is about the adequacy or inadequacy of their search and whether they're acting in good faith in doing the search or trying to hide the P, in this case, hide the critical evidence. And that discovery, it will start soon. The latest update is, what is today? 23rd?
23rd. yeah.
3 days from today, we have a 5-page brief due to the magistrate judge to explain why our discovery plan, which we have given to the magistrate judge now, we've given them the details of who we pose, how many document requests we want, how many interrogatories we want to do. The government wants to limit us to virtually nothing. They want to pick 2 people that we can depose, not people we select, but people they select to answer the questions, which is not going to work for us. And they don't want to do any document requests at all. They just want to answer interrogatories, which means the lawyers can help them answer the questions in secret and then they can sign them. So the magistrate is going to decide those competing discovery arguments on February 4th, or at least hear an argument from us, sort of like we just did with the Second Circuit. We're going to have an argument before the magistrate judge on the discovery dispute. And our brief is due in 3 days on that, and then the hearing a few days after. So we'll let you know, but pretty soon we're going to have a discovery map that are going to be authorized to follow with the power of the federal court.
Great. There's a FOIA that me and another friend of mine are working on with the NSA with
Good
regards
luck on
to, yeah. Well, what's interesting though is that these records relating to metadata that was that's been captured over from 1992 all the way up to like 2002, I think it was, relating to satellite telephone communications from bin Laden and other suspects of the hijackers, and to other hijacking and hijacking people in the United States. There's like I can't remember how many terabytes of data there is.
No
It's been confirmed that the data exists, and we want to get that data so we can interpolate it and figure out what was said in those telephone conversations, because the NSA was wiretapping that stuff. And there was an executive order put out classifying that material for about 25 years or 20 some years, and that date has passed.
That's
So it's now
helpful.
open. It's open.
Has
so
it not
it's,
has it not been reclassified for another period of time?
Not at this point. Not this point. So
Let me tell you something, Gene. You may want to know about that. Let me help you in that
I'm
case.
Ed, by the way.
That's it. Yeah.
Oh,
Yeah,
who's,
that's Ed asking you.
who's talking? Wait a minute. Let me get my glasses on. So, Ed, you're doing the NSA thing?
I'm doing the NSA thing. Yeah.
Okay. Well, that'd be a good one for you, Gene, but that's another point. So, something you may all want to know. The government, the DOJ has a policy that says in matters where state secrets might otherwise be invoked, which I'm pretty sure they're going to invoke that defense to your FOIA lawsuit there at some point if they haven't already. It's not going to help them that their time period expired. But keep this policy in mind. If you need it, I'll send it to Gene. He can get it to you. There's a policy that says the government will not invoke the state secrets defense in a lawsuit or otherwise in a request if the purpose of invoking it is to cover or hide wrongdoing, commission of a crime, or embarrassment of the government.
Yep, I am very familiar with that policy.
Okay, good,
Yep.
good.
Yes, thank you for that. Good reminder. and for everybody else on the call too. So,
Yeah.
all right. Well, thank you, man.
Yeah. So
Anyone
what?
else?
Oh,
Yeah.
sorry. Go ahead.
No, go ahead.
Well, one last update, which you may not know to ask about. There is another lawsuit going on in federal court by architects and engineers.
NIST.
Okay.
Oh, we're losing.
Against NIST.
There you
Against NIST. Can you hear me now?
You're coming back.
Okay, so it's a lawsuit against NIST by AE. It's about the denial of their request for correction on the Building 7 study. And we filed a complaint. The government filed a motion to dismiss. We have until the end of this month, which isn't long, to file an amended complaint. And then the government will file a new motion to dismiss. And then we'll get into the thick of that case. And that one will no doubt involve standing arguments again. The difference in that case is, interestingly, it involves a statute that wasn't involved in the earlier decisions on standing, and that is the National Construction Safety Team Act,
Yes.
which requires NIST to do these reports and make them public, which gives a basis for informational standing that didn't exist in other cases. So it'll be an interesting one.
So the three of those together, I think, are, I love it. The idea of where we are with the Second Circuit Court of Appeals, Dave Cole's FOIA request lawsuit going forth, and the NIST lawsuit with AE. It really seems like the three of these tie together in a loose way and could really provide some power for 9/11 Truth and Justice here.
Well, they were part of a strategy developed a few years ago that the Lawyers Committee put together with AE. They're not as loosely connected as you might suspect, and they do have a synergy. And there's another piece to it. The DC Circuit case we brought that we lost when Merrick Garland was on our panel in the DC Circuit, and the Supreme Court didn't hear it, was about the 9/11 Review Commission, 2013-2014, where Congress had mandated that the FBI look at all 9/11 evidence that the original commission had not looked at. And the Ed Meese Review Commission sort of blew that obligation off and just looked at what they wanted to and didn't look at demolition evidence or the Saudi evidence, blah, blah, blah. So we sued to compel that. Now, you might wonder why I'm talking about that since we lost the case. The strategy on that case had two components. Only the first component was about litigation. The second component was, if we lose in litigation for the reason we did lose, which was the way Congress had worded the mandate, we can go back to Congress and have them reissue the mandate with better language, because they had put the details of the obligation to look at all the evidence, not in the language of the statute, the Congress did. They put it in legislative history in a Senate report only. And so the court decided, well, there was no obligation to issue a report in the statutory language. So we don't need to look at the very clear congressional intent in the legislative history. And so Congress didn't get what it intended. So our backup strategy on that is to go back to Congress and have them fix it by issuing that same mandate in the language of a statute. And if the Congress is really interested in getting an answer to their question, they will do that. So that's another piece that fits with the other three you mentioned, Gene.
Forgive me, which case did we lose there? Did you say the one in DC?
It was the Lawyers Committee, Robert McIlvaine and Architects and Engineers against the FBI.
Oh,
DOJ, about the 9/11 Review Commission, the Ed Meese
Yes.
Commission. And that's the one where, they should have looked at all the 9/11 evidence in the new commission in 2014, but they did not.
that's the one I'm actually part of, .101, with the 100 videos that were unreviewed with all the Pentagon.
The Pentagon, that was one of the sub counts in that complaint.
So that's what you're saying there. There's no more of that one. That one's done.
Well, I didn't say that.
Okay.
It's done in litigation, and it's alive before the Congress. And
Okay.
maybe we'll be calling upon you to help us with that part of it.
10-4. Yeah, I wanted to reapply for that FOIA request and press them not to be so specific on the hours or the distance. They obviously said that they have 100 videos that are unreviewed, so I don't know how to be more general in my request, but
Well,
I want those
not,
videos.
yeah, you may not want to be, we're going to be doing some more FOIAs. So if you want to put that one back
Okay,
on our radar to help you be the requester and represent you, we will consider
excellent. Okay,
doing that with you.
thank you.
Are we good?
I think if there's anything else, I don't have anything else. Anyone else for Mick?
Oh,
Mick,
Ray's got his hand
Oh,
up, but
sorry.
we've had Mick for a really long time.
We
I'm
have.
good. Thank you, but I'm good. Go ahead. I enjoy talking to you guys.
Thank you. Ray, go first, then I
Except
see
for Gene.
Alfred. I see Alfred chomping at the bit next. Go Ray. Ray first.
Yeah, hello, Mick.
Hey.
When NIST did their report and they leave out calculations, is that a problem?
That is a problem.
Okay.
That's a real problem.
If they mention it in their report that they left out calculations, is that a problem?
I would say so. That issue is in the suit that AAE has, Architects and Engineers has alive in the DC District Court right now. Their request for correction that was denied by NIST, a big part of it was what I call the black box approach that NIST used. Black box approach means all the calculations that went into their modeling and went into the computer code to put those calculations into force in the computer have remained secret. They published their report. They said they did those calculations by way of the computer modeling, but they won't let anybody see them. So you can't tell whether they were right or wrong, whether they tampered with it or not, whether it used improper legal principles, improper mathematical formulas, bad input data. And that's at the heart of the current lawsuit by AE.
Yeah, but that's 7. But if you talk about
It
1
is.
and 2 and they did the same thing, they left out calculations.
Well, it's a good point, and I feel free to continue to remind us of that. I forget where it was that issue came up recently. There need to be FOIAs on the towers, and there probably needs to be litigation on the towers.
Yeah.
You might want to send us an email or something on that.
Okay. Yeah, I'll do that.
If you want to send me an email, I'll loop us all in together then.
Yeah.
Great. Thank you,
That's
Ray.
a very, very legitimate point.
Yeah, because I read the NIST report and it's clear that they mention in their own words that they leave out calculations, and I think that's rather strange to do,
Yeah.
because if you leave out certain subjects, you can create a lie. Eh?
I would say so. I mean, I
Yeah.
used to teach mathematics for 10 years before I became a lawyer.
Yeah.
And if I tried to do something like that in graduate school, they would have flunked me in the blink of an eye.
Right.
Okay, thank you.
You're welcome.
We do know gravity is the loading function of blah blah blah. I'm just kidding. That was horrible. So remove that.
Although
Anyone?
professors could get by with that sort of thing, they would just say, and it follows immediately from above without ever explaining it. But that's another story.
Yeah.
One last
Yes.
question, Mick.
Yeah.
How many lawyers from the Lawyers Committee are actively part of the lawsuits? I don't know how many are actually in the committee, but I'm just curious.
Billions and billions, to follow the famous slogan from Carl Sagan. At least I wish it were billions and billions.
Yeah.
Go ahead. Well, on the lawsuits, I can sort of count them for you. It doesn't take very many lawyers to do a lawsuit. That sort of begs the joke, which I'm not going to go to, about how many lawyers does it take but we won't go there. But for the DC Circuit case that we lost, that Supreme Court would not hear, that was John Clifford and I. John is a lawyer in DC. He's not per se a 9/11, truth activist. He's a practicing public interest-minded civil litigator who joined us in that case. For the FOIA suit for Dave Cole, it's myself and David Colapinto. David Colapinto is a well-known plaintiff's lawyer and whistleblower lawyer. And you probably know I'm also a whistleblower lawyer, but he's done a lot of work with his colleagues, Cohn and Colapinto. And they also run the National Whistleblower Center. He joined us in that FOIA lawsuit. So two of us are doing that. In AE's case, that's pending, the one we just talked about. It's me and John Clifford again. In the Second Circuit case, it started out as me and General Cayle. General Cayle is a New York attorney who was on our board, not currently on our board, but helped us with that lawsuit. So I try to have a partner in every one of these cases. There are good reasons for that, which you might imagine. So it usually, but we don't have the resources to do more than what it takes. So typically it's just 2 of us per lawsuit. We haven't had the resources to do probably the biggest legal challenge we could bring. I think I may have mentioned it very briefly in one of our earlier calls, and we still don't have the resources to do it. But it would be probably the most powerful legal challenge that could be brought on behalf of family members or any victims of 9/11, including survivors. And it would get at the heart of a government cover-up. But at the moment, we don't have the attorney or the money resources to do that. We're hoping that will change. At the moment, has not.
And I'd like to reiterate, and you know this anyway, but and Alfred has been pursuing this very actively. Anything that we can do as a group to help you find help. I don't know what that would look like, but you could tell us what that would look like. And let us, if we can do some of the things that we're capable of, that would help you move along.
Well, I think we're going to be better able to do that sort of collaboration now that this argument is over.
Right.
At least after February 4th, after the discovery and the FOIA suit is over. I've been kind of busy with cases that seem to be getting some traction. And when you get those opportunities,
yeah, of course,
you really have to focus on them.
Right.
But we do expect to have an expanded FOIA campaign that we're willing to work with you on. We do expect to try to recruit more lawyers, which we can work with you on. It's going to take probably at least five experienced lawyers to commit some real time if we're going to do this major challenge I've been subtly referring to. Plus, we're going to have to raise a chunk of money. And we're talking about probably $1 million or something to do that lawsuit. And Danny Sheehan says maybe $10 million is his estimate. And for those who didn't get to listen to the other side of the news program 2 days ago, Danny Sheehan joined us for that. Had a good discussion with him and Richard Gage and Barbara and the hosts. But, big litigation against big government is just as expensive as big litigation against big industry. And there's no cheap way to do it. I don't have the resources to pay for it. And I barely survived getting to where we are. I do have cases, not 9/11 cases, because you probably realize I'm not being paid full time to work on 9/11. And I'm subsidizing myself. That is coming to probably close to an end in terms of practicality. So we may have a decision point soon and where we go with our strategies because of resources, even at a time when our strategy seems to be starting to bear some fruit, which would be unfortunate. But we do what we can when we can. But you can help us reach out to lawyers. I'll try to get you the long promised language for that. You want to be careful about how you do it, because and the same thing is true on fundraising. If y'all want to try to raise money for us, we're probably never going to try to talk you out of helping us with that. But how you do it has to, is important. You have to be very careful how you do it. So we're not appointing any independent agents for fundraising, no matter how energetic they are in wanting to help us. You're going to have to help us do it according to a plan we create. And you can get the word out. It'll still be a lawyers committee pitch. You'll just help us distribute it and maybe put in a good word for us. And the same is going to be true for the pitch to lawyers. You're probably going to be handing them something I wrote, maybe with my signature on it, and then putting in your encouragement for them to talk to us about it.
Right. Just give us what we need and we'll do the distribution.
Well, I think we already, Facebook should have given you guys the $2,100 I raised.
Well, we got, thank you, Gene. We got
that. Okay, good.
Yeah, appreciate it. So we will get that to you, Sandra. I'm prioritizing what I do, and there's quite a few things on my list, including your requests, which are, no one's disagreed with doing those things yet. So I think we're going to do them, but I can't do them all. And someone else could pick that up, arguably, but everybody at the moment is deferring to me to quality control legal stuff. And I appreciate that, but it adds to my schedule burden.
Jane gave
So,
us something to do additionally. She gave me a video. Jane, you're on here as well. Something with
Jane?
the Motley Rice lawsuit, and wanted us to listen to see if we could find any nuggets in that.
well, yeah, it's an important task. I may want to suggest we redirect you to other tasks than that one
Okay.
and give that one to paralegals or lawyers. That lawsuit is a mess. Because it's so big and
Yeah.
there's so many things that have been filed on it. I agree with Jane that it needs to be digested very thoroughly. And
Yeah.
no offense to any of you, and some of you may have a little background to do this, but I do think it takes someone knowledgeable in the law
Yeah.
to do that task in a way that will make us able to rely on the information to go to our next step regarding the Saudi thing is still on our radar screen. And we're not involved in that case at the moment. But, the Saudi evidence was part of our DC lawsuit that we got dismissed on standing. We haven't given up on pursuing the Saudi connection.
So
Uh,
nobody from Motley Rice or Creeder and whatever, or the families, has anyone reached out to you guys other than Bobby McIlvain and the few that we do know?
Well, we do have good communications with some family members, but we don't have an official relationship with the organizations for the family members, and the lawyers doing the Saudi lawsuit have not chosen to communicate with us.
Right.
We've invited them to.
Hmm.
We're willing to talk to them. It is, but I'm sort of sympathetic to them putting myself in their place as lawyers for the families in the Saudi case. If they were to communicate with us about what we know, I don't think it would be attorney-client confidential. And I think they would have to turn over to the government and the Saudis everything we tell them and everything they tell us. And if they do get into discovery, I think they're trying to get in there now to some extent. So it may be awkward for them to talk with us in the moment. There may be a way to accomplish that with an attorney-client privilege. And there is at least one way I'm aware of, which we don't have the money to do yet. We have considered intervening in that case. And I can't tell you more about that at the moment.
Understood.
But it's an ongoing concern.
Thank you. Ray, you had another question for Mick?
Yeah. I just posted in the chat a picture from the NIST report and what they did not investigate. It's clearly mentioned in their own report that
Well, I guess let me preface this with for Mick that
but he can read it on
Yeah.
on their own, and I think
Ray's got an angle that he comes at rather frequently with Richard and on here about explosions, explosives, whether there are explosives on the plane or in the building. God bless him for that. That's his angle that he's coming at, so that you understand in reading this.
Well, I understand the point, which it's a procedural one, an important procedural one, which is in any other walk of life, an attorney or a scientist or an architect or an engineer would not be allowed to try to get a remedy from a court or an agency or an academic institution on an argument for which they did not disclose their full analysis, including all their calculations and their data.
Mm-hmm.
It's supposed to be transparent and reproducible.
Yeah.
And if it's not, it doesn't have credibility. And that's true in most court cases as well.
Yeah, but it's what's mentioned is what they left out of their calculations in their computer models, and it's in their own words. They did not investigate the explosions, the overpressure of the explosion, what took place as the plane crashed. It's incredible. It's
Well,
like leaving out the bomb of Nagasaki. You know, it's an explosion, and you have to calculate the explosion.
Well, I think your point is well taken. I don't know if it would lead to a different result. I mean, the bottom line is the key evidence on the explosives use doesn't have to do with jet fuel or the planes. Jet fuel is not going to be that explosive.
Mm-hmm.
it burns. And in
That's
this
what
case-
they say. That's what they say. They,
Okay, our time is up. Oh, now we're back again.
I
yeah.
got a little
So,
fancy.
no problem. So my point is simply that if you go to the measurements of extreme temperatures, which jet fuel doesn't get you to,
Yeah.
building contents don't get you to, you go to corroded
Sulfidation.
thank you very much. Attacks on the steel.
Yeah.
Temperatures are required that jet fuel and building contents don't get you to, even if they burn forever.
Yeah.
And you've got these little metal microspheres that, as I understand it, correct me if I'm wrong, are created not only when metal is melted at extreme temperatures, but they're vaporized into the air and then they cool in the air, which gives them their cylindrical, microscopic
Spherical.
form.
Spherical, but yeah.
Spherical, not cylindrical, spherical. Thank you very much. And that's known. That's how they're
Yeah.
created.
Mhm.
So there is an ironclad case here. It's one of those when you've ruled out everything else, what remains has to be the true thing. Science has done that on the demolition evidence, and the extreme temperatures are a big part of that. What these other calculations that you're talking about, Ray, that have been left out would show to complement that or just give a fuller picture, I don't know. I'm all for that full disclosure.
Yeah. Because the
Not
heat,
yeah. Go
the
ahead.
heat happens on that floor where before the second, the first tower comes down, the second tower to be hit. It's the metal dripping from the floors where the planes hit. It's a significant point on the building which was compromised by heat.
Well, it was
and-
compromised by something,
Yeah,
and heat probably, yes, and heat
Yeah.
caused by something.
yeah,
And what it was caused by depends on how much heat you're talking about.
yeah,
And if it was extreme, nanothermite can explain that. If you look at that one photograph of maybe Tower 2 on the corner where you have these sort of spark-like flowing metal with sparks coming out,
yeah.
that looks like thermite in progress to me.
Yes, that's what I think. Yeah,
Yeah.
yeah. Okay, thank you.
Thank you all for being
Yeah.
patient.
Thanks, Mick.
Take care.
Well,
folks.
thank you. Have a good one.
Thank you, Mick.
Thank you, Mick.
Awesome. Well, that was awesome.
Yeah.
Mick is so gracious in coming on and explaining that in layman's terms. I love all the that are here because you all bring something to it, and I'm happy with just leaving it at that. That way, we could say that this war room was all about the oral arguments. Unless anyone else has anything else to share.
No.
No. All right. And you guys. Have
Yeah, I have a
great-
question real quick.
Okay.
Hey, the LC for 911.org, the Lawyers Committee website,
Mhm.
do they post updates?
They do.
As far as how the, what evidence they're focused on and the process by which they have to do this?
They might not get into the weeds as much as you're thinking there, and the updates don't happen as often as we like them. That's why we have this show here, kind of talk through it. We try to stay on top of what's the newest information. But yeah, if you go to, I made a shortcut, 911lawyers.org, or if you, LC4FOR911.org. The front page, they're getting better at getting their updates there. So that, Tom, that's where you'd want to keep an eye on.
Okay, thank you.
Mhm.
Hey, Tom, have you joined 911public.org?
911public.org.
Sign up.
So yeah,
No,
Sean is great in helping us plug. On that note, we created a public directory for those 911 Truth advocates that want to connect with each other and aren't afraid about putting their, name or their state location. Feel free to share as little or as much as you want. Just a side note with you guys, Richard is doing the same thing with the community hub, and I'm behind trying to get that working for him. A few more complexities because he wants to add in groups and websites and things like that. So it's looking like these two projects might become one and the same. Keep an eye on Richard Gage 911.org, and there's a community
You may be
hub.
migrating.
But if you go to 911public.org, it'll either be its own separate entity or it'll redirect to go to that that directory on his site, which is still a public directory. So it's great being able to connect with you guys, see you guys on a map and look you up and see where everybody's at. And we can allow.
And just
That's
a reminder,
That's 911public.org.
Yep.
Okay, thank you.
and just before we wrap it up, just a quick reminder, since we're focusing on action items 1 month at a time. For those who have not been on the call in a while, this month we're going to focus on street activism. We want to see pictures on our Facebook page, which is 9/11 War Room on Facebook, of what you've done with posters, stickers, banners, whatever you can put out in public. The idea is to get the visuals out there for Joe Smith and Joe Blow to see as they're walking by, driving by, sitting in a washroom stall, pumping gas, wherever you want to put the stickers, wherever they're visible, just get them out there. And we're going to focus on this until the end of February. And we'd really like you guys to do this and send us the pictures so that we can motivate others to do the same thing. And encourage everyone. It's more fun to do it together. It's like a group outing, but virtual. So, we're all in this, doing this together.
Great call, guys.
Anyone else for the group? Bruce coming in at the last minute. Welcome, Bruce. We're just leaving now. It was Bruce, if you get a chance, once I get this uploaded, it was a great debriefing from Mick Harrison about the oral arguments and all kinds of litigation. So
Yeah.
I'll try to get this up by tomorrow here for everybody. Everybody have a great week. Thank you so much for tuning in.
Yeah. Talk to you next week. And we'll have Fran next week.
Yes. Fran and
Thank you.
the psychologists.
Fran and the psychologists.
Adios,
I
everybody.
see you guys.
Thank you for setting it up, Gene. That was great. I
Yep.
really enjoyed it.
Thank you.